Hi and welcome. I'm Rick Newman, Executive Director of the American Museum of Tort Law, with another in our continuing series of talks with interesting people on interesting and timely topics related to the law. My guest today is Larry Kramer. Let me tell you a little about Larry. Since 2012, he has served as the president of the William and Flora Hewlett Foundation. Before that, he was the dean of the Stanford Law School in California. He is a nationally known scholar on the Constitution and civil procedure and has taught at a number of leading law schools, Chicago, Michigan, Harvard, and Columbia, among others. And he is an author, too, of a number of books and articles, one of which is The People Themselves, Popular Constitutionalism and Judicial Review, which will be my segue into welcoming Larry and our talk today. Larry, welcome. Thank you.
Thank you. Welcome. It's good to be here. I do have to add, I was at NYU also, mostly because actually I was there for the longest period of time and did much of my best work with the support of that institution.
Excellent. We're taping this on November 4th, 2020, the day after the election. And as we sit here, the results are unknown. So at this unsettled time in our nation's history, it seemed fitting to discuss something else that is or may be unsettled, the Supreme Court. We're all familiar with the story. Barack Obama nominated Merrick Garland to a seat on the Supreme Court 11 months before the end of his term, and the Senate, led by Mitch McConnell, refused to even consider the nomination. That seat was thereafter filled by President Trump's nominee shortly after he took office. Then, most recently, after the death of Ruth Bader Ginsburg, President Trump nominated Amy Coney Barrett, and the Senate not only considered her nomination, but consented to her nomination, notwithstanding that it was 2 months or so before the election.
Like a week.
Yeah, people thought that that was perhaps hypocritical. I think it was in reaction to that the New York Times ran this series of articles by a number of constitutional scholars under the heading, How to Fix the Supreme Court. And of course, you were one of the authors. There were a number of different perspectives presented, and you took, I think, the most bold stand saying, pack the court. So first, what does that mean? And then why do you espouse that?
Yeah, and of course, right, nobody likes using the P word. Because it has these bad connotations. So it's enlarging the court. But, you know, for me, the ultimate goal, you really have to step back and think about what the role of the Supreme Court is supposed to be. So you can never divorce it entirely from politics. The decisions have political consequences necessarily. I think of it as though, so the Supreme Court is inherently going to be political in a weak sense because its decisions are going to shape politics. But when and is it political in a strong sense, where the justices are actually using their position to advance a political agenda of their own? And whether and to what extent the court takes that position actually depends on who's on the court, how they got there, and the way in which the other branches of government and the people at large believe the court should function. Are they willing to just let it do what it does and say, okay, well, that's the court, so we will defer. So all of these things are inherently tied into a kind of political system in which the court is inherently a part of that system. But the goal is to at least create a process where there's as little of the strong politics as possible. Mm-hmm. And we've lost that, right? Yeah. I mean, basically, at least since the court's supremacy was established in the 1960s, and it was only in the 1960s, the power of the court has grown, and as the power of the court has grown, the significance of adding a new justice has grown with it. And so now it's all about finding a young person, the younger the better, who has your strong agenda, who you can get on there, who will be on there for a really long period of time, extending your politics. And the whole thing shapes the justices and makes them all more political. And so it's all focused around this appointment process. So how do we get back to an appointment process that is itself something that does less to facilitate the worst kind of judicial behavior?
And less overtly political.
Right. And, you know, my simple thinking about it is it really maps onto the classic game theory situation, right? What got us to mutually assured destruction in international relations and nuclear weapons, which is the idea that we develop regimes where we cooperate for the benefit of all.
Mhm.
And then if and when those break down, usually because one party defects from cooperation or something like that, when they break down, how do you find your way back to cooperation? Because that's what we have. For a long time, the process of choosing Supreme Court justices, while it was never utterly without controversy, was relatively uncontroversial. People would put leading jurists on the court. They might lean a little this way or lean a little that way, but it was always done with the sense that you were trying to find people who would be really profoundly dedicated to trying to find a jurisprudence that spoke to the country.
Mhm.
And now it's shifted to advancing an ideological agenda. And that's really been a product of the last 30 or 40 years. And so the breakdown in cooperation, how do you get back to it? Well, what we learned from the game theorists is the only way to get back to it actually is if one side defects, the other side has to do the same thing, right? And they say both sides need to learn that neither side is going to win this way. And you can only learn that if both sides are defecting. So if the Republicans, as they have taken this really strong, outrageous effort to just pack the court, they're doing the court packing with their ideologues. The only way for the Democrats to respond is by doing the same thing in return, but not by sitting around and waiting for some justices to die or retire and hope that there's a Democrat in power at the time to replace them, but by using the unquestioned powers that Congress is given in the Constitution to add the justices now.
Yeah, we should note, by the way, there have been 9 Supreme Court justices since 1869, but the number is not set in stone. We've had a Supreme Court with 5 justices, 7 justices, 10 justices. There's nothing that prohibits changing the number of Supreme Court justices.
Well, and more than that, those earlier changes were themselves done for reasons like what I'm describing. So when Jefferson got elected in 1800, the Federalists who were leaving power at the time didn't want him to be able to control the Supreme Court, so they shrunk it from 6 to 5 so that he would have to wait for 2 retirements before he could make any appointments. Right. Then during the Jacksonian period, they expanded it so Andrew Jackson would get some appointments and expanded it even more when Martin Van Buren was president. Then, Lincoln comes in. Now you've got a party switch from Democrats to Republicans. Lincoln comes in, he gets 3 appointments and it's still not enough because the court is so Democratic. So Congress expands it from 7 to 10 in order to give Lincoln some appointments. Lincoln's assassinated, Johnson comes in, they shrink it again because they don't want Johnson to have appointments. Johnson loses an election, Grant gets elected, they increase it again. And then of course there's the famous Roosevelt court packing, which he didn't end up packing the court, but that's only because he got everything he wanted without needing to actually carry it all the way through. The court reversed itself and he got a retirement, filled the court with a justice, and he was...
Right. In the last, I don't know, I guess since the Warren Court perhaps, the Supreme Court has become this sort of oracular body, highly respected. Public polls show a lot of support for the Supreme Court. And there's the sense that they are intended to be somehow above the fray, the final arbiter of the Constitution. Although that is also not without controversy, whether the Supreme Court is in fact the final arbiter of the Constitution. That's been disputed for 200 years.
Well, it used to be disputed. It was disputed for the first 200 years. That has clearly in the popular political culture changed. As I say, that change took place, look, very simply, the dispute over the scope of the court's authority existed right from the beginning, right? And it was always a dispute between progressives who favored limiting judicial authority and conservatives who favored strong judicial authority, although what it meant to be a progressive or a conservative has changed over time.
Right.
But they always lined up that way. Those who favored popular democracy opposed judicial authority and vice versa. And that lasted all the way through the Warren Court. And the Warren Court is the first and actually only time in American history where you have an activist progressive court. And so the left flips in that period and the right stays right where it is, which is it still believes in strong judicial authority. And so the debate over the final authority of the court is actually settled. It doesn't happen in a day, but across the 1960s and 70s, it comes to be accepted broadly in the culture that the court should have the final say. And you see that. That's why the Bork hearings were so cataclysmic, because this other change had taken place, where for the first time it was like, oh my God, who we put on the court decides our rights, and we're stuck with that. Right. And the other interesting development that takes place is the traditional debate over who has final authority shifts after the Warren Court. Everybody agrees it's the Supreme Court, and for the first time becomes a debate over how to interpret the Constitution. And now you have a conservative liberal split, not over who has final authority, but over how to interpret.
Right,
And
which
that's what we
makes
live in today.
selection of the justices that much more fraught.
Exactly.
Which is why these norms about how judicial selection occurs become so important.
Right.
My question then is the system so broken that game theory says we have to now expand the court as a way of teaching the Republicans they can't do this? Or can it get still brokener, to use my new favorite word, by which I mean that the Republicans, when and if they take control of the Senate, say we're going to expand to 25 justices, or we're going to shrink it to 4. You know, how do we get to a point where we restore normative behavior for selection?
So I'd say two things to that. So one is, when you play these games, it's always possible that you get the bad result, right? If you play chicken, the ideal in chicken is somebody's going to swerve, but if neither person swerves, then both die. And so it is possible that you could go into some downward spiral. History suggests that doesn't happen. I mean, it's not like this is the first time this has happened, and it's happened in multiple times. And in multiple times in the past, actually, we have settled into new cooperative norms.
Mm-hmm.
I think this time, and this is my point in the Times, which is you can actually do both at the same time. It's not just to undo what the Republicans did by adding some justices, but at the same time offer a new cooperative norm that actually does work equally fairly for both. So that when the Republicans regain power, as they will someday, this is all assuming, by the way, that Biden wins the election,
Right.
They have no reason to disrupt what you've replaced it with. So for instance, my ideal solution would be if Biden wins and he has the capacity, you add 2 justices,
Mm-hmm.
right? And that neutralizes what the Republicans have done. And then you put in place this system that was developed by Roger Crampton and Paul Carrington, in which you're adding a new justice every 2 years. Every Congress adds 1 new justice, with the 9 most recent appointees being the one who hear and decide the merits cases, and the others hearing cases in the lower courts, helping decide which cases to be heard, administering the courts, doing all the other things that judges do. So it's consistent with the Constitution. But now, as long as there's an appointment every 2 years, the stakes for any single appointment aren't so great. You no longer have the incentive to put a child on the court because they're only going to get to decide those cases for 18 years. And so you can think about like really, really great people who are a little older. You ensure that the court is never too far out of sync with where the rest of the country is in terms of who's on it, so that they can act independently, but you don't have people whose sensibilities are 50 years out of date, and so on. So it actually creates a cooperative regime that is equally fair to both parties, and you can move forward.
Right, because I think that's the great impetus for this, a sense or a felt notion that the Supreme Court composition, attitude, and perspective has fallen out of alignment with American values, or at least with some large percentage of American values, stimulating this urge to try to rectify it. Do you think that this is likely, assuming Biden wins, do you think that there is enough support for this, or is the oracular nature and the public deference to the image of the Supreme Court so entrenched after 40 years that it's the third rail and no one is going to want to do this?
You know, like all these things, I actually think it's entirely a matter of political leadership. I don't think it's locked either way. So I think it is possible for someone to come in and make a change, but they have to lead. They have to lay out their case. They have to explain it. They have to defend it. They have to not back off at the first pushback and persuade the American people that they have the right idea. Now, for what it is worth, the way this election is looking at this moment, it's moot. Because even if Biden wins the presidency, it does not look like the Democrats are going to have a majority in the Senate, at which point they don't really have the option to do anything. So it was all presupposed on having the capacity, which they would then have to seek in the next midterm election.
And my final question is, the New York Times article sort of begged the question, it assumed its conclusion that the Supreme Court needs to be fixed. Is that a view that you think is correct? I mean,
oh my God, yes. Oh, I think, but I thought, you remember, I've been writing on this since the 1990s. So I think we made a fatal mistake by inflating the power of the court as much as we did. You know, the notion, like either that Trump's biggest accomplishment as president was that he put a lot of judges on courts, like something is seriously awry with your democracy when that is a claim, or that you should vote for Trump over Biden or Biden over Trump because of who they're going to put on courts.
Right.
Like, whoa, our court is way out of whack in terms of the power that it has. And then not only have we given it that power, but we've done it in a way that has so highly politicized both the appointment process and the judge's decision making, as much as they may pretend or, I believe, delude themselves. You can't sit in their context. I can tell you on almost any case how all 9, and if not all 9, 8 of the 9 are going to vote just from looking at the question presented.
Mm-hmm.
There's something deeply wrong with that.
Right.
And so there's no question that we need to scale the court's role back in our democracy and to reconstitute an appointment process where the justices are using something other than ideology to decide their cases. Can I make one other point?
Yes, please.
So historically, it has never been the case, anybody who's a lawyer knows this, right, that the law decides these cases. The Supreme Court decides 75 to 80 cases a year now. Of them, most of them, they just need a decision, it's fine. There are 5 or 6 cases every year. That's why we care about the court. Right. And in those 5 or 6 cases, the reason we care about them so much is because their consequences are big, and because, in fact, the law runs out before you get to a decision.
Mm-hmm.
You have to bring something else to bear to finish deciding the case. So what's that going to be? So historically, at least some number of the justices, I think it's bad to give them final say, but if you're going to give it to them, at least some number of the justices came from, they had been senators or governors or cabinet officials or even a president. They had real experience in the political world, so they understood the consequences of what they were doing. And there's a big difference between seeing something from a functionary position and being the person responsible to decide.
Right.
And then you pulled them out of politics and put them on the court, and they could bring the wisdom that came from that experience to bear when they made that final decision. Mm-hmm. And the court was situated in a way that made that possible. So what's happened in the last 50 years, there was the first mistake of giving them supremacy. But once you made that mistake, then there was what followed from it, which is the increasing drive to, you can't put anybody on the court now if they've actually done anything in life. Right? You can only put people who are legal technocrats and who've kept their head low, who you're picking because of their ideological commitments, but they've never done anything except be good technical lawyers. But of course, when you get to those cases where the law runs out, that's exactly the set of skills you don't need. And all they have is their ideology to decide, and that's what they're doing. And that we should fix.
And it further results in these kabuki theater hearings where the nominee says nothing for 3 days. And then that's it, all done.
I mean, I thought Barrett's reached new levels of embarrassment, though, right? When Dick Durbin asks her, could Donald Trump deny someone the right to vote on account of race? To which the answer is, of course not. The 15th Amendment says you cannot be denied the right to vote on account of race. Right. Nothing simpler than that. And instead, she said something, well, there is this doctrine of extrinsic constraints, and it might limit what the president can do. And Durbin says, you mean like the 15th Amendment? And he reads it to her. And he says, so does that mean that he can't do it? And she still won't say no. Right. She's clearly been instructed by her handlers that under no circumstances do you answer any question. And so she gives, this, and it's so ridiculous.
Right. Yeah, it's just theater. It has
nothing to do. It's embarrassing for her. It's embarrassing for Congress. It's embarrassing for us as a country.
Yeah. So we do need to fix the Supreme Court.
Yeah, we do.
Thank you very much. This is Larry Kramer. By the way, let me give a quick plug. This may not be a book for everybody, but the book, The People Themselves, Popular Constitutionalism and Judicial Review, is a brilliant, incisive history of how the Constitution came into being in terms of what role the judges and judicial system were going to play with it, and carries it all the way through to 2004 when it was written. It really gives the reader a great education background into the roots that underlie these vitally important questions. So this is the author. This is Larry Kramer. Thank you again very much for taking the time to talk to me. Appreciate it.